Hello and welcome to today's webinar, co-sponsored by DAISHA, the Drug and Alcohol Testing Industry Association, and the Current Consulting Group. DAISHA's mission is to provide education, resources, and advocacy to those involved and interested in drug and alcohol testing. Visit daisha.org to learn more about how you can benefit from the many services provided by DAISHA. The Current Consulting Group is a tenured team of industry experts with complementary disciplines spanning the field of employee screening. CCG partners with its clients to increase their access to quality information, expand their knowledge of products and services, and improve their performance, allowing them to optimize their profitability and their clients' return on investment. Today's webinar is entitled State Drug Testing Laws, What You Should and Must Know, and will be presented by Bill Current. We will now hear from Bill Current.
We want to acknowledge DAISHA for co-sponsoring today's webinar presentation on state drug testing laws. And in particular, we have something very exciting to announce today. One of the services that we provide at the Current Consulting Group is an online subscription service for state drug testing laws at statedrugtestinglaws.com. And so today, as part of today's webinar, we are announcing that statedrugtestinglaws.com is now available, the subscription service is now available through DAISHA for DAISHA members. And so we call the product the Ultimate Guide to State Drug Testing Laws. It's available at statedrugtestinglaws.com, and now there's special pricing available for DAISHA members. I'm going to tell you a little bit about statedrugtestinglaws.com as an intro into today's presentation. An annual subscription to our service, the Ultimate Guide to State Drug Testing Laws, includes 7 services, and these are all available in a 1-year subscription through DAISHA. And if you subscribe, or when you subscribe, you receive your own username and password. This gives you access to all of the online information that's in the subscriber-protected sections of statedrugtestinglaws.com. But we have individual state laws, charts for every state. Some states have several charts, or more than one chart, I should say. We have single-issue charts in case you want to just look up the status of pre-employment testing, for example. In all 50 states, we have single-issue charts on those key topics. We also send out regular drug testing legislative updates on state legislation. Those go out at least quarterly, but you get updates in between the quarterly reports. You receive our monthly newsletter, State Drug Testing Laws Monthly, which is an e-newsletter devoted entirely to state drug testing law issues. You receive our weekly news service, Drug Testing in the News. That is also sent out via email. And you also receive invitations to webinars that we do through statedrugtestinglaws.com throughout the year, and we inform you of DAISHA webinars that are coming up as well. The 7th service that you receive, and I think most people appreciate this perhaps as much as anything, is you get to email or call us with your state law-related questions. So if you have a question about what's this really mean in Minnesota when it says you can't terminate for a first-time positive, you can email us. We'll give you a response to that. It's part of your subscription service, so there's no additional charge for it. Each individual state law chart has over 40 line items of detailed information about a state's particular drug testing law. And in addition to the regular chart, there's usually, for almost every state, extensive notes where you can go in and you can find explanations. So as you ask us questions as a subscriber, we're providing an answer to you, but then we're also updating our chart so that we're focusing on the issues that are important to you. A typical chart looks just like this at the top. It has a heads up, Iowa is a drug testing friendly state, though some restrictions apply, and you'll find up in the upper right corner the statutory citation for the Iowa Code and the Iowa Administrative Code, and you can link to those laws through that section of the chart right there. We give you the key issues at a glance. These are the same for every state: drug testing circumstances, specimens permitted, instant testing, etc. And then as you get into the meat and body of the chart, you'll find a section on policy issues and which types of testing are permitted, for example. You'll find a section on the practices and procedures of drug testing, Just pick any line item on there. For example, collection procedures, the fourth line down, required. And then you see testing procedures in the notes section. You just click on the word notes and it'll take you right into the chart where you'll find information about the collection procedures that are required in Iowa. And you can see all throughout the chart, there's lots of blue notes. You just click on those, and it'll take you right to it. And then the bottom part of every chart is the outcomes. What happens when you get a result? How fast do you have to report it? What manner do you have to report it in? Things of that nature. And then the incentives and penalties, if there are any in a particular state. As well as you look down, you'll see right in the middle, workers' compensation reduction and denial and unemployment compensation and denial. We'll give you the status of those two areas of law in every chart. So, for example, in Iowa, there is a workers' comp reduction law. It is Iowa Code annotated Section 85.16. You click on the notes and it'll take you right to, not to the code, but it'll take you to the notes section of the chart where you can find extensive information about that. Same for the unemployment law in Iowa. And then we just started a new section we want to make you aware of. We've created individual state law charts on the status of marijuana in the workplace for all 50 states. So you're seeing here an example of the marijuana in the workplace chart for Colorado. And usually these state law charts on marijuana will have information about any case law, for example, like in Michigan, there's a lot of case law on medical marijuana. You'll find examples of that in the notes section of the marijuana charts. But in addition to the individual state law charts on drug testing, you'll also find that there's a dedicated section just on marijuana. And when you go into that section, you'll find individual state law charts for every state on the status of marijuana. So, end of the commercial. If you're interested in subscribing as a DAISHA member, just go to our website, statedrugtestinglaws.com, click on the DAISHA subscription page, and it'll take you right to it. You'll find that DAISHA members get a $100 discount off of our normal subscription fee. And if you have any specific questions, we encourage you to let us know and ask us a lot. We have hundreds of subscribers. They use the database service for lots of different things. And incidentally, all of the slides from today's presentation, and we're about to get to the meat and potatoes of the presentation, are available to you. Jessica's going to send you information on how to access the slides so you can have them. And if you want more information about subscribing to the Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com through DAISHA, let us know, because that's the only way to get the DAISHA pricing. So today we're going to talk about state drug testing laws and some of the very basic information and some more advanced topics. I am going to use some charts from our website as examples so that I can illustrate what it means in a particular state when I'm talking about, say, a workers' comp law or a medical marijuana law and how it affects the workplace. But we're going to go through some of the basics and then some more advanced topics. There's a lot of slides. I'm not intending to go through every slide. That would take more than the time that we have today. But you're going to get the entire slide deck. So stuff that we don't have time to really go over in detail, you're going to have access to, because you're going to have the entire slide deck. And Jessica's also going to give you information on how to access the recording of today's webinar. So at the end, she's going to let you know that she's going to send that information to you, and you'll get it probably within 24 to 48 hours. Okay, some basic information, okay? We know there are a lot of questions. We get them all the time at statedrugtestinglaws.com. So we're going to go into sort of these basic questions that we get asked all the time. But I want you to understand something right off the bat. Every state permits drug testing. There is no state that prohibits drug testing. There are some states that are not very friendly toward workplace drug testing, but every state permits drug testing. Every state permits lab-based drug testing. Every state permits urine testing, and most states permit lab-based oral fluid and hair testing. Now, when you get into point-of-care testing or instant result testing, there are some restrictions, and I've got some slides coming up on that. But lab-based testing for urine is permitted in every state, even outside the DOT regulations, which require lab-based urine testing, as well as lab-based oral fluid testing and hair testing. Now, if you're in the drug testing business, or if you're a company that is mandated under the DOT regulations to do drug testing, you're probably familiar with the fact that the Substance Abuse and Mental Health Services Administration, SAMHSA, is in the process of developing regulations that will eventually allow the use of lab-based oral fluid testing. Those regulations are not there yet, they don't exist yet, but they're in the process of development. some point, lab-based oral fluid testing will be permitted under the federal regulations as well as lab-based urine testing. Right now, though, it's important to know that as far as state law goes, outside of the DOT regulations, all but 3 states allow lab-based oral fluid testing, and every state allows lab-based urine testing. Every state permits pre-employment testing and most forms of employee testing. There are some states that restrict random testing, for example, and I've got some slides coming up on that as well. And every state permits employers to hold their workers accountable if they test positive. So those are some basics. There's still some lingering myths out there about the legality of drug testing, but just know that every state permits drug testing. There is no state that prohibits drug testing altogether. Now, State Drug Testing Laws 101. Let's get into some basic things to make sure we're all on the same page. There are no 2 states that have exactly identical drug testing laws. Even Florida and Georgia, which both passed drug testing laws about the same time, Florida first and then Georgia, permitting companies that would drug test in accordance with state regulations to receive a workers' comp premium discount. Those are what we refer to as voluntary state laws. And I've got that 3rd slash line down there at the bottom referring to that. They were almost identical back in the day. Georgia's made a lot of changes to their law, and Florida's made a few changes to theirs as well. Even 2 states that were almost identical at one time are very different now. And that's true all across the country. Even if you're talking about the states that are restrictive, like Minnesota and Vermont, they're restrictive in different ways. And so you can't assume that because you're in compliance with one state, that you're in compliance with any other states as well. Another key point as far as State Drug Testing Laws 101 is concerned is that federal laws preempt state laws. Now, that's true generally, and don't ask me why it doesn't apply to immigration law or marijuana laws, and I'm going to talk about marijuana in a minute. Generally speaking, the rule of thumb is federal laws preempt state laws. And so the DOT regulations, for example, or the Department of Energy or Department of Defense, the Nuclear Regulatory Commission, all of those federal regulations that mandate drug testing of employers that do work under those agencies or who have workers who perform certain types of functions that fall under those agencies, those federal regulations preempt state laws. So I mentioned, for example, earlier that Minnesota is a very restrictive state law. Maine's another good example. There are lots of restrictions in Maine and Minnesota and Vermont, for example, that apply in non-federally mandated drug testing situations. But under the federal mandate, you must do what the federal government tells you to do, even though you may be in a state that restricts that type of testing outside of the federal mandate. And there are other laws like the Americans with Disabilities Act. You may be required to do random alcohol testing under the DOT regulations, but outside of the DOT regulations, if you're just putting a program together in a quote-unquote non-mandated way, the Americans with Disabilities Act comes into play, and it restricts random alcohol testing, even though under the DOT regulations, random alcohol testing is required under most of the federal agencies, under most of the DOT agencies. These federal laws preempt state drug testing laws. They preempt state privacy laws like constitutional provisions that provide for privacy and things of that nature. They also preempt state medical marijuanas and state recreational marijuana laws. I know that you're hearing a lot of things right now about marijuana, and I'm going to take you through some charts, some slides on marijuana in a minute. But the truth of the matter is the federal government and its laws preempt the state laws. Now, the current Department of Justice has decided that they're not going to really do much about medical marijuana, but technically their laws, the federal laws, preempt the state medical marijuana laws. The DEA, the Drug Enforcement Administration, put out a statement back in 2011 reiterating what we already know, which is that marijuana is a Schedule I controlled substance, and because it's a Schedule I controlled substance, it's illegal. And the qualification to become a Schedule I controlled substance is exactly what I have underlined, which is the DEA has come to the conclusion that evidence that smoked marijuana, there is evidence that smoked marijuana has a potential for abuse, that there is no accepted medical value and treatment in the U.S. for marijuana, and that there's evidence that there's a general lack of accepted safety for its use even under medical supervision. And that last point is glaringly true when it comes to state medical marijuana laws, where there are no regulations on the potency, the THC content of a marijuana cigarette, or how often it should be used to treat whatever your ailment may be, etc. And so the federal government's position articulated here in this DEA statement is that marijuana is still illegal. I've got some marijuana stuff coming up here in a minute, and we'll get into that. Another point, all applicable state laws apply. So one of the questions I get constantly, regularly, is I'm a multi-state employer based in the state of Nebraska, let's say, but I'm in 17 other states. So which state law applies to my company? Well, the answer to that is all of them do. So we may write a drug testing policy for you and base it on your home state of Nebraska, but any legal differences on how drug testing is conducted and who can be subject to drug testing, etc., in any of the other 17 states that you're in will require an addendum to your base policy so that your company can be in compliance with all of the state laws that apply to you. Now, you may be in 17 states, and 10 of them can all fit under one policy together because a lot of those states don't have any regulations that differ from your home state. But you may still need 7 addendums to your policy to cover, let's say you're in Nebraska, but you're also in Kansas, which has a very specific state drug testing law. Or you're in Missouri, which doesn't have a state drug testing law, but has an unemployment compensation law that has a direct impact on drug testing. And so you'd want an addendum in there unless you want your base policy to be written to comply with the restrictions that exist, say, in Minnesota. You probably don't want to do that. You don't want to limit your random testing program for your entire company to the restrictions that really only legally apply in the state of Minnesota. All state laws apply. Your policy can reflect all the state laws that differ from your base policy with addendums. But you do have to comply with all the various state laws that you're in. And how do we define that? Well, let's say I'm a traveling salesman. I work out of the Nebraska office, but I travel to lots of different states. So when I'm in Colorado and my random testing number comes up, am I subject to Colorado law? No, because my home base, where I work, and the office I work out of, where I live, is in Nebraska. But if I work for the same company, but I work out of the plant in Iowa, and I live in Iowa, then Iowa law applies to those workers. And that's how you know that. But the important point is all applicable laws apply to your company, and you are responsible to comply with all of those laws. Not that difficult to do, but you have to be aware of that. Now, the second most frequently asked question I get is, what's the difference between a mandatory drug testing law and a voluntary drug testing law? Because some states have mandatory laws, and other states, like here in Florida where I live, has a voluntary law. And so what's the difference? Well, a mandatory drug testing law is one that applies to all employers who choose to do drug testing in a particular state. I mentioned Minnesota. If you're an employer in Minnesota, Minnesota has a mandatory drug testing law. It applies to every employer in the state of Minnesota. And I'm talking about non-DOT testing, for example, okay? Some of these states are very friendly towards drug testing, like Iowa and Kansas, but some, like Minnesota and Vermont, can be very restrictive. You're required to comply with those mandatory laws if you're in a state with a mandatory law. I'll give you another example. Maryland has a mandatory law, but Maryland's law regulates the drug testing process more than the who and the when of drug testing. So generally, through your drug testing provider, the laboratory, the third-party administrator, et cetera, you're going to rely on them to make sure that your process is in compliance with the Maryland law. But if you're in Minnesota, and I keep mentioning Minnesota, I don't mean to pick on Minnesota. It's a great state, but they do have kind of a restrictive drug testing law. And it regulates virtually every aspect of drug testing in the workplace. It dictates who can be subject to testing, when they can be tested, and how testing is going to be conducted. It even dictates what you can and cannot do when somebody tests positive for drugs. In Minnesota, you must comply with that law. Maryland, pretty easy as long as you're dealing with a reputable provider. Minnesota, there's a lot for the employer to know and do in order to be in compliance. Now, the difference between a mandatory law and a voluntary law is that in voluntary states like Florida and Georgia and Tennessee, for example, you don't have to be in the program if you don't want to. You don't have to be in the voluntary drug testing program of that state. But if you want to, you're going to, or I should say as an incentive, they're going to offer you something like a workers' compensation premium discount. I'm going to show you what those are in a second for each of the states that has such a law. But it's voluntary. You don't have to be in the program if you don't want to, and in some cases, employers can't qualify to get into the program because either they're self-insured or it's too large. Some states have designed their programs to be primarily for small businesses. But if you're in that voluntary workers' comp premium discount program in Florida, you must show evidence that you are complying with that regulation in order to qualify for your workers' comp premium discount. And so there's some hoops that you have to jump through in order to do that. But it's voluntary. Here's another thing about states with voluntary laws. Outside of the voluntary law, those regulations don't apply to you. So let's say here in Florida, the law doesn't permit point of collection testing or instant result testing. But outside of the voluntary law here in Florida, there is no other statute that affects drug testing in that way. So I'm free to use a POCT device for my drug testing here in Florida if I'm not in the voluntary program or I'm not interested in participating in that program. Sometimes, however, it's worth getting into that program because, as you can see here, there are some pretty attractive discounts that are available to companies that participate in their state's, in this case, workers' comp premium discount program. Here in Florida, it's a 5% discount. In Georgia, it's a 7.5% discount. That's pretty attractive. And look down at Ohio, they've got two different levels, a 4% discount program and a 7% discount program. So you need to be aware of them. You may want to participate in them, or you may have clients that you want to sort of direct towards that. But be aware that outside of these voluntary programs in these states here, you're not restricted by or covered by those regulations because they're voluntary and they only apply to those companies that are in those voluntary programs. Sometimes I talk to providers here in Florida and they'll tell me what the law says about drug testing in the state of Florida, and they're saying it in such a way that you would think it's a mandatory law that applies to all employers. What they're actually telling me is what's in the voluntary law. And so in some cases, in some of these states, the voluntary law has sort of taken on the appearance of being a mandatory law, but in reality it's not. And that's true here in Florida, Georgia, Idaho, et cetera, et cetera. Now, there's another group of states that have voluntary laws. Let me go in the right direction here. And these are states that offer some limited protection from liability if you drug test in accordance with guidelines that are provided by the state. Utah is a perfect example, and it was the first state to pass one of these limited, I call them limited liability states, where if you drug test in compliance with voluntary guidelines provided by the state, then you are protected from some legal action against your company if you acted in good faith upon the result of a drug test. Now, again, in these states, you may hear people talk about the drug testing law of Idaho as if it's a mandatory law, and what they're really describing is the voluntary law because it has taken on that aura or that appearance. What's important to know, though, is why not comply with that voluntary law in Utah or Iowa, et cetera, because there is some limited liability protection that's good to have. And so even though it's not mandatory in these 6 states, you may want to look into it. Usually the requirements are fairly easy to meet. So those are the two different kinds of voluntary laws. I'm going to skip back for a second. You've got the states with the workers' comp premium discounts, and then you've got the states with the limited liability laws, okay? That's the difference between mandatory and voluntary laws. Now, there are a lot of states that do not have a dedicated drug testing law. You may think they do, but they don't. California is a perfect example. Texas is another example. I hear about the California drug testing law all the time, except California doesn't actually have a drug testing statute per se. But there is so much case law in California, in Texas, in New Jersey, New York, et cetera, that it takes on the appearance of and actually the practical application of a state law. So you must know, and even in the states that have drug testing laws, Let me make sure I'm clear on that. You must know the case law that applies to drug testing in your state. You need to be aware if there are any state constitutional provisions on privacy or if there's any privacy laws, because those can come into play also when it comes to what do you do with a drug test result, who's allowed to know about it, things of that nature. I've got some slides coming up on workers' comp laws and unemployment comp laws, and in this case, I'm not talking about the workers' comp premium discount laws that we just referred to. I'm talking about the regular workers' comp law. There are a number of states that have workers' comp and unemployment comp laws with very extensive drug testing sections. I'm going to get to that in a minute. There are some states like Texas that have drug test cheating laws. There's, of course, you need to be aware of collective bargaining agreements with any unions that apply to you or your clients, because those can have a direct impact on how a company does drug testing. You may be dealing with an insurance provider in a state that doesn't have a workers' comp premium discount law that still wants your company to provide certain evidence or proof of a drug-free workplace. You may be in a state with a State Drug-Free Workplace Act, which a lot of states have that. They don't necessarily require drug testing, but they may require you to have something in place along the lines of employee education, supervisor training. They may require you to have some type of employee assistance program in place if you're a contractor with the state usually. And then, of course, the area that gets a lot of attention today, medical marijuana laws. These are popping up all over the country, and we have an entire hour presentation just on medical marijuana laws. In fact, we just did it a couple of weeks ago for a client, a webinar, which you would be invited to as a subscriber to statedrugtestinglaws.com, and just throwing another plug in there. But I'm going to share some slides with you a little later in today's presentation. We're working our way towards it, specifically on medical marijuana laws. Okay? Now, there are some do's and don'ts. There are some things that are a little bit more advanced that you have to be aware of in order to make sure that you're in compliance with the state laws that apply to you. Let me give you a good example. One of the hot crazes in the drug testing industry over the last 10, 15 years, let's say, probably more than that, 15 to 20 years, is point-of-care testing or instant result testing or rapid result testing. In the old days, we used to call it on-site drug testing. It was a drug test that took place on-site at the workplace and rendered a fairly immediate result, an instant result in 10 to 15 minutes. There are urine POCT products. There are oral fluid POCT products. These are the states that prohibit the use of these devices: Kansas, Minnesota, and Vermont. I put Nevada on there. I always get an argument for putting Nevada on there, but I want to err on the side of caution. Probably not permitted in Nevada. And then New York has this crazy law that requires POCT to be conducted in a state licensed location. While most employers can't qualify to receive a licensed location as a laboratory, and that's what the requirement is. But there are some drug testing providers who can be licensed and are licensed as a laboratory, and if you want to do POCT in New York, you're going to want to do business with one of those types of companies, okay? But as you look at this list, even if we just narrow it down to Kansas, Minnesota, and Vermont, the good news is there are 47 states that do not restrict POCT testing, generally speaking. Now, there are some states with voluntary drug testing laws that do not allow POCT or the use of POCT devices if you're trying to comply with the voluntary drug testing law. Florida, for example. But there are others that do not allow that. Ohio is a perfect example where they actually require, as part of the procedures of drug testing, compliance with 49 CFR Part 40, or, what some people might refer to as the DOT regulations. It's really Part 40 under the SAMHSA regulations, but that, of course, doesn't permit the use of these instant result devices. But outside of all of those things, there are really only 3 states that outright prohibit the use of POCT devices. So that's the good news. Each of our charts, and I'll just show you an example. Minnesota is a good example. Right there in the heads up section or in the key issues section, you'll see one of the key issues in every single chart is the status of instant testing, and we'll show you that POCT is prohibited in the state of Minnesota. But in 47 other states where it says instant testing, all the way over, instead of prohibited, you're going to see the word permitted. Now, there are some states, for example, that do not allow random testing. Remember, I mentioned that earlier. Rhode Island and Vermont are examples. Plus, I might add, the City of San Francisco and the City of Boulder, Colorado prohibit random drug testing. But even in Rhode Island and Vermont, these are states that do not permit random testing. Other forms of testing are permitted. So here's the sample of the policy section of the Rhode Island chart, and if you go under testing permitted, you'll see the main types of testing, right? Applicant or pre-employment testing, reasonable suspicion post-accident, periodic exam, return to duty, random, and follow-up. Now, I put in big bold letters. This is not really how it appears on the chart, the real chart. I put for random, prohibited. But look at all the way under pre-employment testing, permitted. There is some guidance provided, and so we put that in the comments section. But you need to know that if you want to do pre-employment testing in Rhode Island, you can, even though something like random testing is prohibited. Other forms of testing are also permitted, but there may be some qualifications or restrictions that apply, and you'd find that information in our chart. But even if you're not using our charts, you want to go through that state statute to make sure that if you're doing reasonable suspicion or post-accident testing, for example, your policy reflects the language that is in that state law, so that if you're relying on supervisors to administer your program, they've got the information they need right there in the policy that says that post-accident post-accident drug testing can be conducted, but only when reasonable suspicion conditions are met, and then you're going to want to put that in your policy so your supervisors have that kind of guidance. Also might note that, and it's not a common thing to find this, but in Rhode Island, periodic exam, a drug test as part of a periodic exam is not permitted. That's kind of a form of random testing, I guess some people might say. I really see it not that way because you know ahead of time that you're going to have a physical exam and that a drug test might be conducted. But in the state of Rhode Island, they don't permit that. Now, and so that's just a couple of examples of random testing and point of collection testing as two kind of hot contested areas that you've got to be paying attention to as you put a policy together, for example, as you're trying to comply with all the laws that apply to you. You can do random testing in most of the states that you're in, but if you're in Rhode Island, for example, you're in Vermont, there's going to be there's a prohibition on random testing. Another area that comes up a lot, and this is really important, is disciplinary action. What can you do when somebody tests positive for a first time or maybe for a second time in a drug test? There are some states that restrict your flexibility, your sort of the latitude that you have in dealing with a first-time positive result. Minnesota is probably the poster child for this particular issue. So here's the chart, the section on outcomes in the Minnesota chart, and you can see the third row down is disciplinary procedures. There's so much in the Minnesota statute on this particular issue that we just say that there are limitations, but click on the word notes, and it'll take you to that part of the chart where you're going to find a lot of information. Let me tell you, this is not normal. The Minnesota restriction on what to do with the first-time positive is not going to apply in most states. There are some other states that have such restrictions, but Minnesota's a little bit unusual, okay? So let me point out the highlights here. So in addition to the limitation under paragraph A, which is not on this slide, an employer may not discharge an employee for whom a positive test result on a confirmatory test, so it's got to be confirmed, right, GCMS, was the first such result for the employee on a drug or alcohol test requested by the employer unless some of the following conditions apply. So the first one is the employer has given that individual an opportunity to participate at the employee's own expense or as part of an employee benefit plan, either drug or alcohol counseling or rehabilitation program. So there's a responsibility, a burden on the shoulders of the employer to make that offering, even though the employee is going to most likely have to pay for it, or that the employee has either refused to participate in such a program or has failed to successfully complete such a program. So first-time positive, what do? You offer them some type of rehabilitation program that they can participate in. If they refuse to do it or if they fail to complete it, then you can take action on that first-time positive. The Minnesota law applies to first-time positives, not subsequent positive results, okay? The question always comes up, well, what about under the DOT regulations? Well, what about under the DOT regulations? The DOT regulations don't mandate that you terminate someone's employment when they test positive. There are some hoops you got to jump through, right? If you're going to retain that individual, they're going to have to be evaluated by a substance abuse professional. They're going to have to go into some type of counseling treatment program given the recommendations of the SAP, and they're going to be subject to return to duty testing if you're going to let them come back to work, or end follow-up testing as well. But where the federal regulations end, remember I said the federal regulations preempt the state law. Where those federal regulations end, in some cases, the state law then comes into play. And so you have to be aware if there are regulations pursuant to a particular issue like disciplinary actions under a state law that might come into play after the federal regulations sort of end, or if they're silent on that particular subject. Let's say you want to terminate someone for a first-time positive in the state of Minnesota and it was a DOT drug test. Well, you'd need to know the Minnesota law to make sure that you're in compliance. It's not saying that you have to retain that individual, but you do have to give them the opportunity for some type of counseling or rehabilitation program. There are not a lot of states that have those types of restrictions in play. Let me be clear on that. But Minnesota is an example of a handful that do have these kinds of restrictions. Also, keep in mind in states like California, Massachusetts, some of the more sort of left-leaning states, if you will, and I'm not trying to be political, but they tend to be sort of the left-leaning blue states on the map during election night, where they don't necessarily have a state drug testing law, but they have some type of a disability law that goes beyond the ADA, or they may have case law where somebody years ago an employer tried to terminate somebody for a positive result, and there was a lawsuit, and there are conditions now that apply, and the case law sort of takes on the sort of the power and the applicability of a statute. And this is very true in California. California is a good example. As I mentioned earlier, I have people tell me all the time about the California drug testing law. And there is no actual California statute on drug testing like you'll find in Minnesota or Kansas or Iowa, but there's so much case law. And there's a provision in the state constitution on privacy that has been used in lawsuits, that there are guidelines now. There are legal requirements that employers have to comply with in the state of California. Even though there's not an actual statute on that, there's case law that has established that practice as being a requirement. And so be aware of that. Another area of law that is really, really important to be aware of if you're putting together your own drug testing policy, or even if somebody else is doing it, make sure that they advise you on workers' compensation and unemployment compensation laws. I've got a few slides coming up on this, but this is critical. In addition to the states with the workers' comp premium discount laws, as I mentioned earlier, there are states that have, and I'm going to talk about workers' comp as an example, but it applies to unemployment comp as well. There are states with workers' comp laws that have drug testing sections in those regulations. So you need to be aware of that, because if you go to challenge a workers' compensation claim and the individual has an attorney who's aware of the workers' comp law and the drug testing section of that law, if you don't know it and if you don't have it built into your policy and you can't prove that you're complying with it, then you probably don't have a very good chance of successfully challenging that workers' compensation claim. If you do, however, have that written into your policy and you are complying with it, let's say you're in a state that has very specific requirement on how drug testing will be conducted. Maybe it sort of punts on the issue and defers to 49 CFR Part 40, which you'll find in a few states. Well, then in order to really successfully challenge a workers' compensation claim, you need to show that your drug testing program is essentially in accordance with 49 CFR Part 40. That strengthens your position when you challenge that workers' comp claim. If not, there may be some other circumstances that you can use to strengthen your argument, but you wouldn't necessarily be able to show that you're 100% in compliance with the drug testing provision of your state's workers' compensation law. And this is outside of those, workers' comp premium discount laws. Now, let me give you an example. In Iowa, this is straight out of the Iowa statute. No compensation under this chapter shall be allowed for an injury caused to, and I've skipped down to item number 2, by the employee's intoxication, which did not arise out of or in the course of employment, but which was due to the effects of alcohol or another narcotic depressant, stimulant, hallucinogenic, or hypnotic drug not prescribed by an authorized medical practitioner, and then in bold letters, if the intoxication was a substantial factor in causing the injury. Well, let's pause here for a moment, because we're talking about Iowa's workers' comp law just as an example of what you might see in a state workers' compensation law. But you need to also have this sort of factored into your policy. We know that at least from a legal standpoint, drug testing does not necessarily prove impairment, okay? So you don't want to use that language in your drug testing policy unless you're in a state, and there are a few, that use that language. But generally speaking, you want to sort of defer to the phrase under the influence. And in the policy, define under the influence however you want to do it, right? But among other things, a positive drug test result. And you want to be able to document a connection between an accident that occurred and the behavior of the individual who was injured or who caused the accident, so that if challenged, you can come back and show that the individual tested positive, we have a positive drug or alcohol test result, and it was obtained in a testing method that was required by the state or suggested by the state. And we also know that the individual drove their forklift into a wall, and it caused the accident to occur that resulted in the injury. So you want to be able to, put that paper trail together. But as part of that paper trail, you're going to have to show that you did the drug test, that you have a drug test result, and that the drug test result was obtained from a testing method that the state accepts. Okay? So in Iowa, in bold letters, and that's why I put it in bold, if the intoxication was a substantial factor in causing the injury. You see that kind of language in places like the city of San Francisco, for example. You can do reasonable suspicion testing in San Francisco, but you've got to be able to show that connection between, the behavior that prompted the suspicion and some type of evidence or reasonable conclusion that their behavior was caused by their use of an intoxicating substance. Off the beaten path there a little bit. Let's look at one other example, Illinois. Now I'm going to read again. According to the statute in Illinois, it must be demonstrated that intoxication is indeed the quote-unquote proximate cause of the individual's injuries, or that the employee was so intoxicated at the time of the injury that the intoxication was a departure from employment. So again, you need eyewitnesses, you need a paper trail, but it does require that drug and alcohol testing must be conducted according to the National Labor Relations Board. It's a little iffy, wishy-washy there, or the Department of Transportation guidelines. So Illinois is an example of a state where a workers' compensation claim can be challenged based on a positive drug test result, but you're going to want to show that your program met the Department of Transportation guidelines, which are, in addition to the DOT part of the guidelines, whether it's under the Federal Motor Workers Comp regs or FTT or FTA or FAA, that there was compliance with 49 CFR Part 40. Sorry, I was distracted a little bit there because there is no FTT. I think I said that little tongue-tied there, but FTA for Federal Transit or Federal Aviation, Federal Railroad, etc. The most common, of course, is the Federal Motor Carrier Safety Administration, which is the truckers. Okay, let's talk about marijuana for a minute. And we're doing pretty good on time. Let me just say that if you have any questions at all, please submit them if we don't have time to get to them by the end of today's presentation. And we have hundreds of people on today's presentation, but we'll get an answer to you one way or another, probably in response to an email. We'll take care of that for you. Drug testing of marijuana. We have come a long way in the last 10, 12 years. Back in the 1970s, there was a movement to legalize marijuana. If you're old enough like me, you remember that. But it didn't really gain a lot of traction. There really wasn't an appetite among the population to legalize marijuana. So the pro-marijuana people sort of shifted gears, and they started arguing not to so much legalize marijuana generally, but to legalize marijuana for medicinal purposes, medical marijuana. Surely you and I can agree that somebody suffering from some debilitating illness like multiple sclerosis or some form of cancer, that there's a compassionate argument for that individual to be able to smoke a joint if doing so alleviates some of the symptoms of their tragic illness. I can't argue against that necessarily, right? But that was never the end game with the pro-marijuana people. It was always to legalize marijuana, generally speaking. And we're not going to spend time going through that right now, but go on to the website of the Marijuana Policy Project, MPP.com or marijuanapolicyproject.com. Go to the normal website. Go to any one of those websites. They're very clear. They're very transparent. I give them credit for that. Their objective is to get Congress to move marijuana out of Schedule I so that marijuana can be legalized in every state, not just for medical purposes, but for any purpose, just like we see now in Colorado, Oregon, Washington, Alaska. These are the states that have medical marijuana laws, and we've now switched to marijuana green on your screen. It wasn't that long ago when it was just, California. That was the first state to legalize medical marijuana. And every year there's 2 or 3 or 4 states that legalize marijuana in one form or another. Last year there were 5 states that legalized marijuana for medicinal purposes, or in the case of Oregon and Alaska, for recreational purposes, or in other words, just legal. So if you're in one of these states and you haven't legalized marijuana yet, like Arizona, for example, or Michigan, or pick a conservative state on this list if you want to. This is the battleground for the pro-marijuana movement. These are the states they focus on to take marijuana from medicinal use to recreational use. So if you're in one of these states that hasn't legalized it yet, like Colorado did, you're next. You're on their map. You're part of their strategy. These are the states on this next slide that have already introduced legislation for 2015. Now, some of them are on the chart that we just saw, because these are some of the states that are looking at legalizing marijuana, generally speaking. Arizona, Indiana, Kentucky, et cetera, et cetera. Now, you're seeing the District of Columbia on here, and you're thinking, didn't I read an article back in November after the midterm elections that said that the District of Columbia had legalized marijuana like Oregon and Alaska did? You may have read such an article, but they didn't legalize it like Oregon and Alaska did. Oregon and Alaska, even though their laws are different, Alaska is very similar to Colorado. But Oregon, Washington, Alaska, and Colorado have legalized marijuana, and they've established a legal marketplace for marijuana. So, they set up dispensaries. You can go in, you can buy pot, and it's legal to buy it. It's legal to grow it. It gets taxed all the way along the line. It's a legal marketplace for marijuana. In the District of Columbia, all they did is said it's legal to use marijuana. They didn't create a legal marketplace for it. So it's still available from your, corner drug dealer, and it's illegal to sell it, and it's illegal to produce it. But the intent of that law was, and the voters voted in favor of it in D.C., it was to make it legal to use it. Now, anything passed by the D.C. Council is subject to the sort of purview, the overview, and perhaps the restrictions of the U.S. Congress. And so Congress removed that, or they removed the vote of the people in the budget bill that was passed back in December. And so what the voters voted for in D.C. has sort of been neutralized, and it's not legal to use marijuana in D.C., technically speaking. However, you may have read this, the D.C. Council, the City Council, has actually voted to make it illegal to conduct a pre-employment test for marijuana in the District of Columbia. Now, the first attempt at it said that you can test for marijuana in a pre-employment drug test, but it can only be after a conditional offer of employment has been made. Well, unbeknownst to the geniuses in the District of Columbia, that's already something that virtually every employer does anyways. You'd be crazy to conduct pre-employment drug testing before you make a post-offer a conditional offer of employment. Well, once they caught on to that, they came back with a second initiative in D.C. And I don't mean any insults or harm to D.C. or their city council. I apologize if it came across that way. But they've now come back and they've said, well, it's just illegal to drug test for marijuana, period, as part of a pre-employment test in the District of Columbia. That has not gone into effect. It has not been enacted. It's still being debated. But that's the direction that they're trying to go in the District of Columbia. And why do we bring that up now? Because it could, if it happens, it could have a bearing on other states that have legalized marijuana and try to use the same argument the D.C. City Council used to try to say, hey, listen, if it's legal to use in our state like Colorado, then a job applicant shouldn't be penalized for doing a legal thing. Well, we'll see. As I said, I've got a whole presentation just on marijuana that you might want to take a look at, because we go into those issues. We go into the lawsuit in Colorado that's before the Colorado Supreme Court that is challenging that state's marijuana restrictions. An individual was terminated even though he was a registered medical marijuana user when he tested positive for marijuana and things of that nature. And it's worked all the way up to the Colorado Supreme Court. Let me give you a couple examples of what you do see sometimes in state laws. And so this is the Illinois medical marijuana law. And in Illinois, even though it's traditionally sort of a liberal blue state, has really one of the better employer protections built into its medical marijuana that you'll see in any state with a medical marijuana law. Nothing in this act shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace, provided the policy is applied in a non-discriminatory manner. Well, I think we can all agree that we don't want our policies to be administered in a discriminatory manner. So in Illinois, in order to get this past the business community, this is what they had to go with. But it's good. This is good language. This protects the employer. It specifically mentions drug testing. Not all of the medical marijuana laws throughout the country even mention drug testing for their medical marijuana law. Nothing in this act, again, in Illinois, shall limit an employer from disciplining a registered qualifying patient from violating a workplace drug policy. So this law went into effect in Illinois. It's got specific language about the workplace, and I would say that of all the states that have legalized medical marijuana, it's one of the most employer-friendly states just on this particular issue. Minnesota is a different subject. Minnesota passed their law last year. It doesn't allow smoking marijuana. It's not you can't light up a joint because in compliance with the medical marijuana law in Minnesota. But it has some stuff in there that affects the workplace. And we're kind of getting tight on time, so I won't go through all of this, but let me just show you the next slide. A Minnesota employer may not discriminate against a person in hiring, termination, or any term or condition of employment, or penalize a person if the discrimination is based upon, number 2, a patient's positive drug test for cannabis components or metabolites, unless the patient used, possessed, or was impaired by, there's the word impaired, by medical cannabis on the premises of the place of employment or during work hours. Keeping in mind that in Minnesota, it did not include smokable marijuana, okay? But again, if you're in one of those states with a medical marijuana law, you need to be aware of these provisions that apply to the workplace. Now, one of the things we do is we keep track of state legislation all year long. To our subscribers, we send out regular updates on legislation so that you know what's being proposed in your state. In 2014, all of these states passed some type of bill that affects drugs in the workplace or drug testing generally. Some of these states passed specific bills on drug testing in the workplace or in a specific industry. You see 6 of them on that first bullet. Some created or changed their marijuana laws. There were 12 of them passed last year. Again, not 12 states passing medical marijuana laws, but 12 laws affecting marijuana in states were passed. 1 workers' comp law was changed, again, only as it affects drug testing. 5 changed their laws defining what a controlled substance is. That's important because you may be in a state where it allows drug testing for any controlled substance as defined by the state. 2 altered their DUI laws as they affect drug testing, and then there was 1 miscellaneous one. Under drug testing at the top, you see 6. What we're seeing is a lot of legislation now on welfare drug testing. An applicant for welfare or unemployment has to pass a drug test if they're in one of these programs where they're offering financial assistance to needy families or needy individuals. And in some cases, the state law requires the individual to pay for the test, or if they fail a test at any point, they don't necessarily lose their benefits in some states, but then they're subject to more drug testing. I'm not really sure what the logic is there, but it can happen. Now, we're really sort of to the end of our presentation. Again, StateDrugTestingLaws.com is a service that's available to DAISHA members. I do want to let you know that we're in the process of redesigning StateDrugTestingLaws.com. We're expanding it considerably. We're making it much more user-friendly and much more state-of-the-art. I'm not going to go into all of that with you today, but you're going to find in the coming months that it's a much more robust, easy-to-use program that will automatically send out updates. It'll be searchable in all different types of ways. So if you wanted to go in and look at a particular state chart, you could do that. But if you wanted to look at the status of pre-employment testing in all 50 states or in just 6 states, you would be able to do that through the searchable section or engine of StateDrugTestingLaws.com in the new program. It's not available yet. I'm not going to promise it's going to be available before the first half of the year, but we're shooting for May, June, July. Hopefully, sometime in the third quarter of the year for sure. We've got some very talented people working on that. My business partner, Nina French, has a lot of expertise in website development, and she's not a web designer, but she's built a lot of programs in her career, and so she's spearheading that for us. It's just going to be even better than what it is, and right now there's really nothing like it in the drug testing industry. So if you're interested, just know that DAISHA offers this service now, and DAISHA members or people who subscribe through the DAISHA, as a result of DAISHA, get a price that is $100 lower than what we normally charge. I see that we're out of time now. Thank you to DAISHA for co-sponsoring today's webinar. We had a lot of questions, and I've talked past the point of being able to address them, but we will respond to your questions. You will have access to the recording of today's presentation, and you will have access to these slides as well. But in addition to that, if you have any questions at all, please email them in. You can email them at info@currentconsultinggroup.com or send them to me directly at bcurrent@currentconsultinggroup.com. We'll get to your questions. I assure you of that. Thank you for coming on to today's presentation, and stay on the line for a moment so Jessica can tell you how you're going to be able to access all of this information.
Thank you very much, Bill. And on behalf of DAISHA and the Current Consulting Group, we hope that you have found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions via email informing you how to access the recording and the slides from today. Thank you for your attendance today. This concludes today's webinar.